Good afternoon, everyone. It's Ian Cominsky, talking to you as an out-of-state member from Philadelphia. I'm delighted to be here with Bryan Skarlatos this afternoon to talk to you about cutting-edge issues involving the attorney-client and the work product privilege, protecting privilege in an era of tax enforcement. In fact, the material is moving so quickly that you'll see as we go through. We not only added two new cases, which are F4. If you're watching, once they got past 999 F3rd, they started to do one F4TH. So we have two new cases in the TH era. And we also have a case that hasn't even been published yet that we're going to at least touch upon. It was issued 2 days ago. So other than that, we're going to deal with, dated material. I'm being facetious. So we're delighted to be here this afternoon. Let me make sure the slide projector works. Okay. I'll leave this slide open for the whole hour. Now, as you can see, this is my, if you have trouble sleeping, you can read the slide with my background. For purposes of today's proceeding, I made the mistake over a decade ago of writing a volume of a treatise called Tax Fraud and Evasion, which takes up basically every Saturday I have now to keep the material up to date. And so a lot of the material we're going to be talking about today, is in chapter 15 of the treatise. I'm really delighted to have, enough of that, I'm really delighted to have Bryan Skarlatos sitting in, who's with Cominsky and Fink in New York. He just waved. And he's represented individuals, as you say, for years and years and years in the tax litigation area. He's an adjunct professor at NYU. He teaches tax penalties and prosecutions. I tried to do that once, Brian. I couldn't learn another subject matter to sit there and teach. He chairs the annual NYU Tax Controversy Forum, which we hope will be live next year again. He's a fellow of the American College of Tax Counsel, and he has served as chair of committees for many bar associations, including the American Bar, New York State Bar, and the New York City Bar, and we're delighted to have him with us. And again, we're going to be talking about the attorney-client privilege and the work product privilege and what's hot, to use that term, in the area today. And I'm going to turn it over for the initial background to Bryan to go through. Bryan, just tell me when you want me to change slide for you.
You bet. Okay. Hey, everybody. How are you? Listen, I'm just going to do a little bit of an introduction to both the attorney-client privilege and the work product doctrine, and then we're going to jump into some hypotheticals so you can see how this is playing out in the real world. And then in the context of the hypos, we'll discuss recent case law that analyzes similar facts. And what we're focusing on, and the purpose of this program is, when the government often is coming to lawyers and law firms to get information, what the boundaries are for the attorney-client privilege and the work product doctrines. And what you tend to find is that, as many of you probably know, this area is maybe a little bit more complicated than it appears at first blush, or that many people understand. And that when you actually step through each of the elements of the various privileges and possible waivers, the privileges aren't quite as broad or extensive as many people think. And so what we are seeing is a more aggressiveness by the government, especially in tax cases, which is what Ian and I specialize in piercing the claims of attorney-client privilege in order to get documents that many people thought were privileged in the first instance. So with respect to the attorney-client privilege, I don't know how many of you may know this, but it's one of the oldest privileges in common law. It goes all the way back to Elizabethan England. It has a walk-on role in the Charles Dickens novel Bleak House. They talk about the attorney-client privilege. And back then, it sort of stemmed from the idea that a gentleman, back in those days, it was a gentleman, should be free from interference in his communication, in his confidential communications. And out of that, then developed this concept of the attorney-client privilege. The idea, of course, is that it's there to promote full disclosure of facts and circumstances so that a client can get fully informed legal advice. And that benefits not only the client, but society as a whole. It's also sort of an adjunct or a bolster to the Sixth Amendment right to an attorney, so that you have effective counsel only if they actually know everything. So up there on the screen, you can see are the elements of the privilege from Wigmore on evidence. And it is an evidentiary concept. And so just to talk it through, I don't want to read the screen, but it applies, you have to actually break down and see whether each of these elements is satisfied. So, you got to see if there's legal advice. Is the person giving the advice acting in their capacity as a legal advisor? Was the communication really related to the purpose, for of the retention, or was it something else? Was it made in confidence? And really, the attorney-client privilege, as I said before, protects communications about facts and circumstances from the client to the lawyer, but then it sort of tangentially or impliedly applies to the communications back from the lawyer to the client, on the theory that if you just protected what the client says, but not what the lawyer says, you'll be able to understand what the client said. So in effect, it applies both ways, but in the first instance, it's what the client is telling the lawyer. And then, of course, it's the client's privilege to assert or waive, and it applies to any attempt to get it from the client or from the legal advisor, unless you have a waiver. And so all of these elements really require us to sort of step back and see whether a communication satisfies all of these things. So, Ian, you want to go to the next slide?
One second. And 2 days ago, what often happens in the business context is an in-house lawyer will be working for a business, but he can be doing business work or be doing legal work. It's called he can be acting in a dual capacity. And the Ninth Circuit on Monday, the Westlaw site is 2021 Westlaw 4143102, again decided on the 13th, held in connection with a dual purpose communication, i.e., one where it could be, business, the lawyer could be acting in a business or a legal purpose, that they created what's called a primary purpose test. There was an issue about whether the test should be the primary purpose of the communication, or whether litigation could just arise because of the communication. And the Ninth Circuit held, with a little waffling, but not much, that the primary purpose test, which is a narrower test, obviously, then because of would apply, and ordered the production of the documents which were subject, to the subpoenas, which were to the business and a law firm out in California. And Brian said he was involved in this, at least tangentially, and he's again made bad law for the rest of us. So I thank you, Brian. That just came out Monday. Let me go to the next slide. Thank you very much, Brian.
You got it. Anytime. Happy to push it as far as it'll go, but it wouldn't go that far. Do you want to step ahead to slide 6, where we have scope and limitations, and we'll bounce back to this?
Here we go.
There we go. So this is what Ian's just talking about, is that the attorney-client privilege applies to legal advice. But as Ian pointed out, you have a lot of attorneys who act in a dual capacity. You have them sometimes giving business or investment advice. And just because you're an attorney doesn't mean that all of your advice is privileged. It only applies to legal advice. So you really have to look at the substance of the communication and the purpose of the privilege. That is the key to what's going on here. You can't look at whether it's a lawyer and a client and people say it's legal advice, what they call it, that sort of thing. You have to look at just what is the substance of the communication, what's the purpose of the communication. And so this gets particularly hairy in a tax context when you have got a tax lawyer, especially if you've got a tax lawyer who's preparing tax returns. If you have somebody who's preparing tax returns, then what happens is courts are going to make a distinction between whether it's legal advice or whether it's non-legal tax advice. And this distinction is not at all clear because, as we know, there are lots of tax attorneys out there. I mean, I have to say I'm a little bit concerned by some of the recent rulings because I'm often asked by my clients, hey, will this transaction work? What position should I take on a tax return? Should I make disclosure? Should I report the income this year or next year? I mean, I consider myself to be giving tax advice, which is legal advice. Why? Because my advice is based on a statute, on regulations, on case law, the analysis and synthesis of those things, the things I learned to do in law school. Now, what has happened, unfortunately, well, or fortunately, our tax law is so complicated that there's a whole tradition born up where accountants who prepare tax returns will also end up giving a lot of tax advice in connection with preparing those tax returns. And so accountants, non-lawyers, often end up interpreting statutes, interpreting regulations, even interpreting case law and talking to clients about it. That's led to the impression in the minds of some judges that that kind of advice, because accountants often give it, isn't legal advice. My contention is that's accountants who are practicing law. Just because accountants are doing it doesn't make it non-legal. They are interpreting statutes, they are interpreting regulations for the purposes of filling out a tax form, correct, but they are making legal interpretations for the purposes of doing that. And so you can't say that all of that stuff is non-legal just because accountants often do it. I think judges sometimes get confused about that. And so there is a gray area between what is tax advice that's legal and non-legal. I would call it non-legal tax preparation advice, because nobody would say that help in preparing and filling out a tax return, if it's actually filling out a tax return, is legal in most cases. I can see a couple cases where maybe it would be, but in most of the time, if you are compiling your income for the year, compiling a number for the purposes of putting it on a tax return, you do put it on the tax return and then send it to the IRS. That is tax return preparation. And by the way, it wasn't intended to be confidential because you're sending it to the IRS. And even if you did intend for it to be confidential, when you send it to the IRS, it's no longer confidential and you've waived the privilege. So there are a lot of reasons why that tax return preparation advice is non-legal. However, all of the stuff that happens before, if there's a gray area that requires interpretation of laws, regulations, and case law, that should all be legal advice. And even though accountants do it sometimes, doesn't make it non-legal. Now, the trick comes when you've got a lawyer who is also preparing tax returns and actually filling them out. And that does happen. In those situations, you may have the dual purpose situation that Ian talked about, where you've got a lawyer who is giving legal advice and also helping to fill out a tax return. And there may be documents created, or there may be communications, usually an email, that go to both of those purposes, helping to determine whether something is reportable, how it should be characterized, that sort of thing, and also getting the information to the lawyer so that the lawyer can put it on a tax return. And so there's dual purpose. And Ian is right. In the Ninth Circuit, the IRS issued a subpoena to the law firm. And that's something we're talking about today, is subpoenas and summonses issued to law firms to get privileged communications.
That's not your best start, Brian. That's not your best start of the week when you walk in and somebody's serving a grand jury subpoena on the law firm, right?
No, it's not. It's
not a good start to the week.
And it is happening with more frequency. The Department of Justice has actually learned that they can push the boundaries of this. And so we are seeing it happen more and more frequently. Used to be, you would never see a subpoena go to a law firm on the theory that we don't want to get privileged information. Now they're saying most of that information isn't privileged, or the stuff we want isn't privileged. And so what happens?
Or if it's privileged, it's been a crime fraud, and we can get it anyway.
Oh yeah, well yeah, then we're going to get to that at the end. But what happened in the Ninth Circuit is the Ninth Circuit said in that dual purpose communication, where it was partly for filling out the tax return and partly for giving legal advice, what you have to look at is, was the legal advice a primary purpose of the communication? They actually didn't say the primary purpose. They left open the possibility that you could have two primary purposes. Kind of confusing for me, but maybe two primary purposes. What they didn't want is they didn't want judges to have to figure out what is the most important or predominant purpose. They just say a primary purpose, and they're express that they're leaving this open. But if you've got that dual purpose, the burden is on the taxpayer or whoever's asserting the privilege, usually the taxpayer here, to say a primary purpose was legal advice, and therefore it should fall within the scope of the attorney-client privilege. And then Ian raised the last one, which is if the government says, hey, the client was using the lawyer to help violate the law, usually in these circumstances to evade tax, you're helping them engage in a tax shelter or leave stuff off the return or do something that's criminal, then the privilege goes poof anyway. And I got to tell you something, to get that crime fraud exception, the bar is very low. The government doesn't have to prove that the crime occurred. The government doesn't have to prove probable cause that the crime occurred. The government only has to prove reasonable cause to believe a crime occurred. Not probable, reasonable.
And that
so
the
it's a
and that the
pretty
lawyer
big
was, and two steps, and the lawyer was used in furtherance of the crime.
And then once you prove
that
that,
isn't
then
much
the
either.
lawyer, yeah, that the lawyer was used in furtherance and that the specific communication issue was in furtherance of it. And so once you have that, then boom, you have the crime fraud exception. So
The last, 1 second, Brian. Last time I had an oral argument on this in my lead circuit, I practiced mostly at the Third Circuit, and the government and the court's asking the government attorney hypotheticals about when the crime fraud exception would not apply, and they asked the hypotheticals to the government attorney, and the government attorney said over a course of about 30, 45 seconds, the only time crime fraud doesn't apply are when there's no crime.
yeah, when I no,
Applies.
when I don't think there's a crime.
Right. Yeah, right. It always applies.
Yeah.
Very
It always
tough.
applies if I can state a reasonable basis to believe a crime occurred and that the communication was in furtherance of that. So that is very broad, actually. Listen, do you want to just go back one slide? I won't spend much time on that, Ian. Go back to slide 5. Okay, so there is an interesting area, especially in tax, when somebody else is brought into the zone of privilege, often an accountant, but it can be other people like an appraiser, an engineer, some other type of expert. And the lawyer or the client invites that person into the zone, the confidential zone of communications. And in those cases, that person's presence and disclosure of information to that person does not always violate the privilege or break the confidentiality under certain circumstances where it's necessary for the legal advice. I'm going to stop there. There's a famous case, United States versus Covell from 1961 in the Second Circuit, and Ian's going to talk about it in the context of the next hypothetical. So, Ian, you want to jump forward now to slide 7, and we'll go to work product doctrine. So
Done.
Yep. Good. Okay. So what we got, oh, you know what? And just before we touch on work product doctrine, I want to give a shout out to the federally authorized tax practitioner privilege. There's a separate privilege. It's not the attorney-client privilege, but it's very similar. And it applies to federally authorized tax practitioners, read accountants. And the idea was back in the late 90s, the AICPA went to Congress and said, you know, all of these lawyers are stealing business from us because they're telling their clients they've got this special attorney-client privilege. And we don't have anything like that. And we're losing a lot of business. And the AICPA and other lobbying groups was able to convince Congress to pass Section 26 USC 7525, which created a new privilege, not for lawyers, but for federally authorized tax practitioners. And it says that any communication between a taxpayer and a federally authorized tax practitioner is privileged to the extent the communication would be privileged if it were between a taxpayer and an attorney. So it's equal to the attorney-client privilege, except there are important exceptions here. It doesn't apply in a criminal case. It doesn't apply to a matter where the US is not a party, okay? And it doesn't apply if a tax shelter is involved. So the bottom line is important to remember, this privilege is definitely there, but it's not going to apply when you need it, okay? It's not going to apply when you really get into litigation over, you know, is this a tax shelter? Should there be penalties? Or especially in a criminal case, that's when you really want to be careful. So it does apply in a general tax, civil tax situation where you're just in tax court and the United States is a party. But it's not going to apply then in the divorce case that spins out of it or an SEC enforcement action. It doesn't apply in those situations. So
we're going to talk a little bit about that because it's covered in a case called BDO Seidman, which is further in the slides.
Right. So you got to watch out for that. Okay. Now, in addition to the attorney-client privilege, keep in mind that there is this doctrine of work product. It was initiated by Hickman v. Taylor in 1947, and it's later been codified in the Federal Rules of Civil Procedure 26b3. And it basically says any materials prepared by an attorney or a party at the direction of counsel in anticipation of litigation or to be used in this current litigation will be protected from disclosure. And basically the idea there is that they're trying to say, we're not going to let one party get the thinking and work product of another party to assist in the litigation. You can't lay back and then hit the other party with, give me all of your work products so that I can then prepare for the case. It's very different from the attorney-client privilege. The real key here is whether something was prepared in anticipation of litigation. You need that nexus. And there's a lot of litigation about what is in anticipation of litigation. Was the document prepared for the purpose of using in the litigation, or was it just prepared because of the prospect of litigation? I would say sort of the dominant, there's a circuit split on that. And the dominant theme is it's because of the prospect of litigation, but some circuits say it has to be specifically for a particular litigation. So the key to work product, though, everybody, is that it's more broad than the attorney-client privilege. It can apply to more things because the attorney-client privilege is designed for the reasons we said, to protect the specific communications relating to legal advice between a lawyer and a client. That can actually be kind of narrow in a lot of circumstances. The idea of something being prepared because of the prospect of litigation, it can be more broad. And so think about that. Never forget about work product, because if something isn't covered by attorney-client privilege, there is a real chance that there is a possibility of litigation on the horizon. And that's why the client was sending the email to the lawyer or the letter was prepared. So work product could be more broad. All right, so that's work product. That's attorney-client privilege. We're going to jump into some hypos. Oh, here you can see, man, forget it. That's what I just said. We're going to jump into some hypos. The first hypo is going to talk about when you can bring an accountant into the privilege. The second hypo is going to talk about when the government goes to a law firm and says, give me the identities of your clients, which, by the way, they can and do. The third hypo is when—
And they are doing, when they can do, they are doing.
Yes, they are doing it more and more. And then the third hypo is when the government goes in and executes a search warrant at a law firm, and now you want to get back to privileged documents. So we're going to explore the scope of the various privileges. I'm going to turn it over to you.
Yeah, and if you think it's a bad day if you get a subpoena, it's the worst day when you walk in and there's 15 agents saying, good morning, Mr. Skarlatos, we want to seize your computers.
That's a very bad day when that happens.
That's not a good, and they always show up early. They never show up after lunch. It's always 6 in the morning or 7 in the morning.
They show up that early. They want to make sure that people are home, usually when they're doing it at home, but they show up early at the office. I think it's because they think earlier or first thing, it's harder to get your lawyer on the phone.
which may be correct, except for those of us who seem to work 7 days a week. So we're always available. Okay, hypothetical one. A practitioner has a well-developed, albeit niche practice in handling tax controversy and related commercial litigation. The practitioner engages in a variety of transactions with tax professionals, and the following has occurred. The attorney is retained in a criminal investigation involving tax issues. As this is a norm, the accountant was contacted and retained pursuant to the attorney's standard Covell retention letters. You're going to see, and I assume most of the people in the audience, it's just called a Covell letter now, even though we're going to talk about the origin for a minute, U.S. versus Covell. The accountant undertook work pursuant to the engagement and had a number of meetings with the attorney and the client. Much to the surprise of the attorney, he's provided with a copy of a grand jury subpoena issued to the accounting firm, asking for all the documents and information gathered during the course of the engagement. With great outrage, he calls the prosecutor. The prosecutor states that the accountant has engaged in, quote, mere accounting work, and the Covell privilege cannot apply. Does the attorney-client privilege apply? Here's the question. And then we go to the cases. By the way, I'm involved in a case now where the government just called up the accountant and said, do you really have a Covell? Why don't you talk to me about what you're doing for a minute? Happily, the accountant said, we do have a Covell and we're not talking to you. But they actually called up the accounting firm and said, we want to make sure you really have a Covell. Tell us what you're doing. Who knows if it wasn't a sophisticated, firm, what would have happened?
Yeah.
Anyway.
And I just want to point out this question, do you have a Covell? That implies that you have to have the Covell letter in writing. That is best practices because it's going to prove the existence of the necessary relationship that Ian's going to talk about. But I would argue that even if you don't have it in writing, as long as the substance of the relationship is there, the privilege applies.
That's correct. Yeah, it's much, much safer to have a Covell.
Oh yeah, 100%.
And the other piece in the cottage industry, which isn't as clear, is whether you have to have the client pay you to pay the Covell, or you can just have the client pay the Covell directly. That is clear whether you have a problem if it doesn't go through the law firm to pay the Covell. I haven't seen that challenge, and most practitioners now, a lot of them don't want to be involved with the administrative headache. And as long as your agreement says that the client can pay the Covell directly, you're probably okay there. I don't think it has to go through Do you still have them going for you,
I
Brian?
don't think it has to go through. It's just another element of proof that no, what's happening here is that the Covell accountant is being hired to assist the attorney. If the attorney's paying, it's another element of proof. It's not absolutely necessary.
What do you do these days? Do you still have it go through your
No,
firm?
we still, in more cases than not, we still have it go through us just to bolster that element of proof. But we're talking more and more about, maybe letting that go.
Okay, anyway, this case, this goes back to a case which is, over 60 years old now. U.S. versus Covell. A circuit court judge by the name of Friendly, who was a terrific writer, wrote the opinion. And you want to talk about a bad day. Covell gets retained by this law firm, and he's working at the law firm's direction, and he gets himself a grand jury subpoena, and it's right near the statute of limitations period to expire, and he goes into court, and he won't answer the question because he said, I'm acting on behalf of the lawyer, and the judge says you can't have a Covell. The judge says only a lawyer can have privilege. It's an early case, and unless you're the lawyer, you can't have a privileged relationship. An accountant, you've got to answer all the questions. And Covell, the accountant's name was Covell, gets held in contempt. That's not a good way to start the day either. And he gets detained. He's immediately detained. They eventually indict the lawyer and the accountant's client, and he finally gets himself bail. So the case is up on appeal in the Second Circuit, and Friendly writes, we can see, it's worth reading a sentence or two. We can see no significant difference between a case where the attorney sends a client speaking a foreign language to an interpreter to make a literal translation of the client's story. The second, where the attorney, having some little knowledge of the foreign tongue, as a more knowledgeable non-lawyer employee in the room to help out. A third, where someone to perform that same function has been brought along by the client. And fourth, where the attorney, ignorant of the foreign language, sends the client to a non-lawyer proficient in it with instructions to interview the client on the attorney's behalf and then render a summary of the situation. And he concludes with, the analogy of speaking a foreign language is not irrelevant to the appeal. Accounting concepts are a foreign language to some lawyers, and in almost all cases, and almost all lawyers in some cases. And that's the line which has percolated over the years. And the case ends up getting remanded because everybody took a diametric position. The government said you can't never have an accountant, and the law firm said you always have an accountant. And if the court had stopped there, we wouldn't have to do hypothetical. But the court didn't stop there. The court goes on to write, what is vital to the privilege is that the communication be made in confidence for the purpose of obtaining legal advice from the lawyer, which is what Brian just reviewed. If what is sought is not legal advice, but only accounting advice, and they cite two cases, or if the advice sought is the accountants rather than the lawyers, no privilege exists. And now we have 60 years of litigation based on one loose sentence. And the cases they cite, the first case was Olander, which is a Ninth Circuit case. That was easy. Well, it's easier. The accountant was actually doing tax returns. And if anything's relatively clear, if you're a lawyer preparing a tax return, which you know is going to the service, it's a privilege waiver. So you normally can't have privilege on the tax return itself or the information going into the actual return. There's an argument, as Brian was alluding to, about the advice before you start putting numbers on the tax return. But the actual return itself and the numbers you put on the return, since you know it's going to the service, is deemed a waiver, and that's fairly black and white law. Then they cite this other case, Reitzman versus Kaplan, which ended up in the Supreme Court in a slightly different context, where Pete Marwick got brought in, and they said that Pete Marwick's work papers were accounting work papers, not legal work papers, and that one's not as clean. And that has started 60 years of litigation with the service pushing now. I didn't see this for years and years, and in the last decade or so, the service has started to push and say that the accountant really was doing accounting advice, and he wasn't really assisting the lawyer in getting into that. And Brian and I were both involved in a case in the Eastern District. The lead defendant was a guy by the name of David Brooks, who's now passed away. But this was called U.S. versus Hatfield, who was the initial defendant. And the argument in Hatfield was just what we're talking about. Brooks's lawyers had retained an accounting firm, and the accounting firm was instructed to assist in determining whether an outside auditor for a publicly traded company that the taxpayer was involved in was filing the appropriate disclosure statements and tax returns, disclosure statements for purposes of the SEC. So the law firm, the personal law firm of Brooks, retains the accounting firm, and the accounting firm assists the outside auditors for the publicly traded company in straightening out, which turned out to be a couple little inventory issues and the like, which, as Brian recalls, resulted in a massive indictment eventually in the Eastern District for securities fraud. That the inventory was right and the company was overstating its earnings. And so the issue is whether the information which was in the possession of Brooks's accountants pursuant to the Covell was protected. So in the first instance, you had a real Covell arrangement. You had that Brooks's lawyers were paying the Covell, that the Covell was, trying to work with the outside accountants. And, what was the court going to do? The court, at first blush, upheld the Covell in the initial opinion. And in the second opinion, they decided two things. One, there was no Covell because they was retained really. The court first holds that the law firm was retained to provide corporate accounting services, thereby assisting the independent auditors preparing public filings. So that little exception in Reisman just got broadened substantially. And they held that Brooks's lawyers Covell didn't work because they were doing just accounting work. Then if that wasn't enough, the judge created a suspender argument, a second argument, that the disclosure was made to this other accounting firm, and therefore there was a waiver of the privilege. And that law isn't clear either. Most of the authority is you can have a discussion with an independent auditor for a publicly traded company, and it doesn't waive the privilege. The judge here took the minority view that the accountants had the ultimate allegiance to the corporate creditors and shareholders, and therefore their public watchdog function required a level of independence, and therefore the disclosure to the outside accounting firm waived the privilege. So when we were briefing this, everybody figured if you had the Covell, and there was a Covell, and it was followed, and there was a letter, and the payments were followed carefully, and they got information in confidence, whatever they did with the outside accounting firm was going to be protected, and the government couldn't use it. Wrong. You remember that case, Brian, right? We spent a couple of minutes on that case. Yeah, and that was the end of the privilege. The more usual, go ahead.
Well, that's what I was getting at for everybody out there is when you're asserting attorney-client privilege, and especially when you're doing it with respect to an accountant under the Covell doctrine, you try to expand the scope of the privilege to someone else. You really have to look at what's happening and the substance of what's happening. Is it legal advice? And the government's going to come at you hard saying it's not legal. It's SEC advice. It's business advice. It's non-legal tax advice. It's something else. So you got to keep, you got to try to keep that Covell limited to legal stuff.
And Fitzpatrick's the more usual case, which is from 2011. An AIG executive resigned and claimed there were improprieties in connection with, companies he was involved with on behalf of AIG. There's a bunch of entities called Murray Hill entities. And they claimed, so the AIG came in and hired KPMG, and they did an internal and did a Covell letter, and this was a civil suit, and they claimed that, among other arguments, that the service of product KPMG were purely of an accounting nature and there's no privilege. Same argument. This time there's a different result. The accounting firm was performing forensic accounting services, considerably part of the function of accountant, but that does not alter our finding. The functions were serving a bona fide need of the attorneys to assist them in undertaking their counseling and other lawyerly functions. So this gave this short shrift, as opposed to Hatfield, which gave it full shrift and said the privilege was waived. So you got to be careful. Look, there's a whole cottage industry. We're only on problem one, Brian. We're never going to get to all three. I mentioned that in passing, but there's a whole cottage industry as well about what you put in the engagement letter, about how much language you put in, about what the accountant is actually doing. Lawyers, everybody gets lazy at some point in time, and for a while, you were just putting in, you're going to assist our law firm with providing legal advice to the client, and that was the entire Covell statement. Now, I usually put in at least a sentence or two what those accountants are actually going to do and how they're going to assist me in providing legal advice. Brian, what do you do up there?
I sometimes put an extra sentence in. The problem is the flip side of being more specific is that you define the exact scope. And then when the accountants slip outside the scope of what you said in the letter, then you're sort of admitting that it's no longer covered by the Covell privilege, that they've now gone outside the scope. So I try to do it a little bit more than just legal advice, but I still do leave it general enough so that I can argue that all types of communications fall within the scope of that privilege. It's a trick.
Yeah, I put, among other things, they're going to, then I put a sentence. Then I put a sentence in. But
and then there's all kinds of things. The accountant is supposed to make sure that they bill separately for this. In the Edelman case, you had an accountant who was the trick comes when you use the same accountant that the taxpayer uses for their tax compliance work. That you use the same accountant that the taxpayer uses for their tax compliance work. And then the question is this really a separate engagement? Is it really part of their tax compliance work? So you have to make sure that they, separate billing number, they keep the payments separate, that they keep the work on this work, on this privilege matter segregated and confidential and all kinds of stuff like that.
If you have a big enough engagement, I've gotten a number of engagements from the big four over there, what's left of the big accounting firms, and they'll have two teams. They'll have a compliance team, and then they'll have a tax return preparation team. And they keep the teams segregated. And once the compliance work is done, they get over the transom, as I put it, the numbers needed to do the tax return. So that's the safest. The safest is you have one accounting firm doing the forensic work and somebody else doing return preparation.
That is the safest, but it's also more expensive, right? Yeah, because now you got to get two people up to speed often on the same topics.
Yeah, the intermediate step is you have somebody like the big four where they have two separate teams in the same firm, and they make sure that team one, other than getting numbers to team two, doesn't tell anything else to team two, and team two doesn't ask anything of team one. So I've done that a couple of times, but where it gets tricky is when it's a smaller accounting firm and they're doing both. I agree with that, and you got to be careful.
Yeah.
Okay, so Brian. We only did one hypothetical at half an hour, so let's see how we do here. Ready? Here we go for hypo 2. An attorney has been representing multiple clients with respect to deferring income through the use of offshore corporations and trusts. If you have been following, this is right from the headlines. Again, the attorney retains an accountant under Covell to assist in providing advice with respect to each individual client's advice. The accountant prepares a detailed memoranda of advice and recommendations with respect to each individual client, which the attorney relies upon in providing the advice. One attorney who's been subject to audit has unreported income and agrees to a civil fraud penalty with respect to foreign entities set up and managed by the lawyer. The attorney and the accountant are then issued what is known as a John Doe summons under 72069. The summons seeks the identity, among other information. I put that because they always seek, they'll seek not only the identity, they can seek the address, they'll seek the amount of the fees with respect to the client. The attorney asserts that the attorney-client privilege applies, and is the forensic accountant and the attorney protected, or do they have to produce documents?
Hey, Ian, before you jump into the case law, let me just take a moment and give people a sense of a John Doe summons. So basically, John Doe summons is when the IRS doesn't know the identity of the person about whom they want the information. And so it's a particularly broad and invasive thing. They don't even know the names of the taxpayers that they want to investigate, okay? But they want information to see whether they should investigate them. And this works when you're issuing a summons to like a bank, a credit card company, some third-party record keeper who's going to have information about people. And you're saying, I don't know who it is I want to, audit, but I just want to see what they got. And that's what the John Doe summons is all about. And so here you can't give the taxpayer notice that this is even happening because you don't know who the taxpayer is. So what does the IRS have to do? They have to first go to court and get an order saying that they can issue this summons. And what they have to prove is they have to prove that the summons relates to a particular group of taxpayers and that there's, again, this reasonable basis to believe that the people may have failed to comply with the law and that they can't get the information from another source. So they basically just got to say, here's a group. We have reason to believe they didn't report their taxes correctly, and we can't easily get it somewhere else. So now we're going to issue this John Doe summons to the law firm. So with that, Ian, I'll let you go. But it's particularly broad.
Yeah. Now, wait a minute. Now that takes you out to, they're using this currently, as we know, for crypto summons, to get crypto information. There was one for Coinbase back in 17. They've been using it this year for Kraken, and they're getting summonses to third parties. For Coinbase, it was easy. They wanted the list of all the clients using Coinbase. But the one for Kraken, they just got approved this year. They're issuing a summons to FedEx, UPS, some banks. And so they've expanded the net. I guess they figure they can issue a now enough summons that they can figure that FedEx items were shipped between the law firm and B or C, and they want to know who B and C are. But that have you seen? I hadn't seen that before, where they're going after FedEx.
I hadn't seen that before, but it illustrates how broad this concept can be if they don't even know who the taxpayers are, if it's just groups of people. But again, this is a technique that it seems like the government is using more and more.
And the only good news for those of you who do tax controversy in the audience, we're going to have more work. Because once they issue the summonses, they're going to start audits or investigations of assorted taxpayers that they get names of for not reporting, in the most recent instance, crypto, or in the older instances, tax planning advice. Now, we broke these cases up. We're going to have to figure out how we're going to get through this. We're probably going to have to summarize some of the circuits, but you'll see those slides for each of the circuits have different case law on this. And the cases have arisen in different fashions. For instance, I'll just do the Second Circuit. And the Second Circuit went to a lawyer by the name of Jerry Skarlatos way back in the 80s. And Skarlatos was known for representing individuals who might get charged in New York in RICO prosecutions. In those days, that meant they were usually organized crime, usually they were mafia cases. Skarlatos had a niche. Was that a fair statement, Brian? He had a niche representing, certain.
He did. Back in the 80s, that was his niche, and then he sort of developed into a more broad white-collar crime practice.
Yeah, so that was his niche in the 80s, and he got, and the government, they wanted information of unexplained wealth of tax law violations. So we provided representation, and they requested information, which he said was privileged. He got a grand jury subpoena asking him to produce his fee records and the identities of the client to see how they were paying them. That's not a good day either. If you've been retained as a lawyer. Let me do an aside on that for a second. If that happens now, if the government can actually trace the money and it's dirty money, which you got paid with, and that's a whole separate seminar about whether you're protected based on what information you knew from the client if it turns out the money's tainted. On one level, you may have to disgorge your fees. That's not a good thing to explain to a managing partner, but I got a nice fee and I'm going to have to disgorge it now. And if it's really dirty money, and you should have known it's dirty money, it's not unheard of these days. They'll indict the lawyer for money laundering transaction. I covered in my class a case called Blair involving a lawyer in Baltimore who ended up with money out of a safe, which was held by a drug dealer, and the safe was stored at a woman's address, and the drug dealer got killed, and the safe gets opened, and all the contents get brought to the lawyer, for quote safekeeping. By the way, it didn't help in that case, Blair, that the lawyer tells the client it was about $200,000. The first thing the lawyer tells the client is it's really on 100,000. So the lawyer pocketed 100 grand roughly before the case even started, and he got indicted for money laundering. And he got indicted for a 57 violation, which created a circuit conflict, which would be to get a program for another day. But they wanted from Skarlatos the name of his clients and how much they paid him. And the Second Circuit had no problem. We've consistently held that client identity and fee information are absent special circumstances, not privileged. And in the Second Circuit, it's almost never any special circumstances, because their follow-up case, which is Goldberger and Dubin, said, unless you're revealing somehow a confidence by the information the government already has, it's never going to be privileged. So if you get a grand jury subpoena, in theory, you got to redact your billing records. Some of the information in the billing records may be privileged, but the dollar amount billed will not be. And depending on what the government then looks at on how you got paid and what you got paid and when you got paid, in theory, you might be subject to a disgorgement proceeding, which is, again, it's better to search warrant being executed, but it's not a good day for a law firm to get that little notice from the government. Let me do one more circuit. The best circuit around was Liebman, which is where I am. The Third Circuit still has a case back from 1984 where it has the same general law, absent unusual circumstances. The identity of the client doesn't come within the privilege. Now, they said the unusual circumstances occur when so much of the communication has already been disclosed that identifying the client amounts to full disclosure. And this was a case where there was a fee deduction issue about whether the fees were deductible for tax purposes. And the government put so much information in their affidavit that it was clear that they knew everything except the name of the client who had been advised by the law firm. So the Third Circuit created an exception that they knew so much that you were in fact disclosing the confidential communication because the government knew the whole rest of everything else that had gone on. But this is the law up here. So unless you want to move to, and it's got limited, unless you want to move to Philadelphia, it isn't going to help you much. So let me shift over to the hot case. We're going to have to move this along, Brian, but the hot case is Taylor Longmire. So take a minute on that out of the fifth. And
sure, I'll talk about the Longmire case.
Yeah.
And the Longmire case really plays off that Liebman case that you just mentioned, Ian, where the idea there was that the government knew everything and they just needed the identity of the client. It was sort of the last link in the chain that would have revealed the confidential communication between a lawyer and a client. They knew the subject of the communication. They just didn't know whether it was Ian, Bryan, or some other guy that was doing the communicating. So in Taylor Longmire law firm, this is a law firm that was involved in advising clients about how to set up offshore structures, foreign trusts, and foreign bank accounts, and that sort of thing. And the government had audited some of its clients, and they realized, oh, geez, this firm is engaged in this business, and we've gotten, money from some of these clients. It's been successful. So we're going to go ahead and hit the law firm with John Doe subpoena summons for the identities of its clients. Why? Because we want to audit them. That's, we have a reason to believe that these people have engaged in some tax non-compliance. And here's the group of people. It's these people who hired this law firm, but we don't know who they are. And so we're going to go ahead and issue the summons. And so Taylor Longmire, the law firm, said, whoa, you're asking for the identities of our clients, and you want that because you want to audit them? So you kind of know enough? Aren't you really asking for privileged information because you want to find out why they came to us? So it's covered by the attorney-client privilege, right? Right, Ian? Is it covered by the attorney-client privilege?
It should be, but the Fifth Circuit didn't agree with us.
Fifth Circuit didn't agree. Basically, Taylor Longmire went in to quash the subpoena saying it's covered by the attorney-client privilege. And the government came in and said, well, I don't know, we don't think so, because all we're doing is conducting an investigation to find out the identity and liabilities of taxpayers who formed an entity using you guys. And they said, that's what they said. We want to find out your clients because they used you and we think that they may have a tax liability. And so we want the identities of your clients. We want the things that you did for them and all of that kind of stuff. The court found that that is not covered by the attorney-client privilege, the identities of the clients in that circumstances. And Taylor Lohmeyer relied on the Liebman case that Ian just said and said, wait a minute, what are you talking about? The government just said, you know, all of this stuff. You know, they hired our firm. You know, they hired our firm to engage in offshore activities, and you think they didn't, you know, pay their taxes. Isn't giving you the identity basically disclosing the nature of the communications that we had? And the court actually said, well, no, the government learned from the Liebman case, and it wasn't that specific what they said. All they said was, we think it could be possible, but it's possible that the clients fully complied with the law too. It's possible that they did everything fine. We don't really know what the nature of the communication is. And so giving us their identity won't reveal the actual nature of the communication and whether they violated the law. And so, yeah, go ahead.
The other piece was they claimed they had to do a privilege log, which they resisted.
Well, I'm going to be honest. I think if it, and you know, it's easy in hindsight, but if there was some way, and it's hard to do a privilege log, you'd have to John Doe 1, John Doe 2, John Doe 3, John Doe 400, John Doe 456, however many clients, and do a privilege log. I think that that may have had some impact because the district court basically said, you know, maybe there's a privilege here, but we don't think the law firm carried its burden in proving the privilege because you didn't give us specific, you know, instances of privileged communications. You can't just blanketly say a blanket assertion of attorney-client privilege and say everything was privileged. But a privilege log here would have been an overwhelming job because I don't know how many hundreds of clients, and then every single communication. And so that's the issue here. The case went up to the Fifth Circuit. The First Circuit affirmed the district court. There was a petition for rehearing en banc. That was denied, and so now they're petitioning for certiorari. I will say that there are a lot of, I don't think they're going to get it. There's a lot of amici out there filing briefs, you know, tax lawyers, organizations of tax lawyers, American College of Tax Lawyers, criminal defense lawyers, National College of Criminal Defense Lawyers. And in the amicus brief for National College of Criminal Defense Lawyers, they actually said, if you don't find in favor, we're going to have a warning in each of these cases, an attorney general warning that says consulting, warning, consulting or retaining an attorney will be used as evidence against you in a court of law. The mere fact that you retain an attorney will be used as evidence. I'm going to let you take it. I'm going to let you take it to the next typo.
Yeah, look, let me just do quickly two other pieces. The seminal case was out of the 9, which is Baird versus Kern. That was a case where the lawyer, the client had a little tax problem. He didn't want the IRS to know about it. So the lawyer made an anonymous payment on behalf of the client, didn't say the client's name, anonymous, to the IRS, and the IRS wanted to know who the payment came from. That was, you know, that's what in the earliest case, and that protected the privilege, set using either the confidence would be revealed, that would be, or they used alternative language of last link. There's a couple alternative formulations, but there they protected the privilege because if you gave him the name, you knew the guy, he or she had a tax liability problem because they made a payment to the IRS. So there it got protected. Then, of course, we go to the 11th Circuit, which has got no traction on privilege issues. I know that's not a surprise to the audience. The first case is Leventhal, which was a cash reporting case, which is the Form 8300, where the attorney was getting money in cash and didn't want to reveal the client identities. And they said that they went through the general case law, whether it reveals the communication, and they went through the last link argument, and they rejected it. Then brand new, it just came out. It's an F4 case, which came out in June, which was a grand jury subpoena involving a politician. And they subpoenaed his lawyer because apparently he was reviewing some of the reports before they got filed. They said and they required him to turn over the records. Now, this got more into crime fraud. So this is what we alluded to at the beginning. So if you're having a bad day, or you think you've had a nightmare, just read 2F 41339 about how loose the crime fraud exception is. And they found that the client could have used the lawyer in furtherance of a crime or fraud. And the trouble is, this case reads even worse. This case reads that the lawyer's got a problem. Not only got used, but he unhappily, this you don't know. But reading between the tea leaves here, between the lines, that the lawyer may end up at the counsel table with the politician he was representing. They found the second prong of crime fraud because the advice was obtained by the candidate. It was personal purchases, but almost the usual in the political arena. But before the financial disclosure statements were formed, and from an attorney who had knowledge of personal purchases. So I don't know what the attorney told the client, but the client filed the forms with the personal purchases. And this is going to be a stay tuned. This is out of Georgia, not Florida, but it's still out of the 11th Circuit.
I just want to highlight what you said, how easy it is. Imagine you're consulted by a client and you give some advice that in retrospect turns out to be a little aggressive and the government is and perhaps wrong, but you maybe thought you were doing the best you could do. The government comes in and says, I want to find out what the nature of that advice is, especially if the client says, hey, I was relying on the lawyer. What are you talking to me about? All the government has to do is say, well, the advice was wrong. And we think the client actually used the lawyer to, learn the contours of the law so that they could step over the line. And then we're going to make the lawyer either an indicted or unindicted co-conspirator. And boom, the attorney-client privilege is out the door and they can get everything. And it's just really, it's a way around or through the attorney-client privilege.
Yeah, we're not going to get to all the hypo through. We got 5 minutes.
No.
Let me just take 1 minute back on crime fraud. The last case I litigated up here on crime fraud, the lawyer said, "I'm not an." It's a published decision. The lawyer said, "I'm not an expert." This is Foreign Court Practices Act. The lawyer said, "I'm not an expert in FCPA, but here's my understanding of the law, and I wouldn't do the transaction that you're talking about." And the court actually held that even telling the client the law, that that's the only thing you did, and telling the client that you wouldn't do the transaction, it was still crime fraud if the client didn't listen. Because the court held that by listening to the law, what Brian was alluding to, the client came up with a method to get around what he thought the law was, and therefore it's still crime fraud. Even if all you did was tell him, this is the law in the FCPA area. Very tough area. Okay, well, at least touch on 3. If not, the group will have to come back next year.
Just a touch to tell them what
that's all we can
issue.
do. Yeah.
An
attorney has been representing multiple clients with a conservation easement, which is another hot area, as the group knows who's on the call. And he's participating in syndicating transactions where multiple individuals are investing in each project. The attorney walks in and finds a team of agents who sees all his cell phones, computers, and hard drive with respect to all his clients. What do you do if you don't have a heart attack first and you can recover from the shock of having 15 agents with weapons in your office? What do you do first? Yeah, Brian, pick one case.
And you pick the case you can do most quickly so we can let these guys off at one.
Okay, the brand new case is August 30th. It's a case out of South Florida. Search warrant case of a office which had a lawyer embedded in it. It was a lawyer actually worked at the client's office, and this is very instructive because the law firm did pretty good protecting itself in the lower court, and privileged information. The government set up a taint team, and the government was told before information could be turned over to a prosecution team based on what they see, they had to come back to the court, and if there were objections between the law firm and what was privileged and wasn't, the court would vet it. So they got a pretty good result. They nonetheless took an appeal to the 11th Circuit saying it was per se improper to have a taint team, that nobody from the government, the taint team is government people. It's per se improper to have a taint team to look at anything which is seized from a law office. And the 11th Circuit held 2 weeks ago, nope, you can have taintines. 2 cases above is one of the cases out of the investigation of Giuliani, and there they appointed what's called a special master. So that's more in vogue, but the 11th Circuit just held 2 weeks ago, you don't have to do it down in Florida. And beyond that, Harbor Health is a good case. If we had another 15 minutes, we could talk about Harbor Health, but I'd stop there. But the problem is there are more search warrants on law firms than ever before. They're not just sitting with subpoenas anymore. They're executing search warrants, or they're executing search warrants on businesses that have lawyers working there, helping the business. And it's become a more and more active area. So the 4th Circuit case is a good case for the defense. The Southern District of New York case is out of Giuliani and appointed a special master. Harbor Health is a brand new case out of the 5th Circuit, which would take a little more time to explain, which is he just got published. And the newest case is the 11th Circuit, which again is not going to find that government taint teams are all improper because it would require too much resources to have a special master in every case. But we had 15 stories where we talk about search warrants of law firms, which we'll have to hold. And I'll stop there. Brian, do we have like one question, or do we have anything? Because it is 1 o'clock.
We have no questions. Everybody's loving it, and learning it.
Everybody either absorbed it or they're having lunch. Okay, look,
Lunch.
Brian and I, appreciate everybody sitting in. Hopefully we can do this maybe on an annual basis. And next year we can start with Harbor Healthcare System and see if there's a new case after in-ray sealed case out of the 11th Circuit at that time. We hope it's been educational and at least a little entertaining for you, and we enjoy doing it, and we thank you for attending. And with that, I'll stop here. Anything else, Brian?
Nope, that's it. Thank you, everybody.
Hey, thanks,
Have
everybody.
a great day.
Bye-bye.
Bye.